important thing to note is that the whole idea of electoral dispute adjudication, or even the determination of cases by the courts, is to arrive at justice. And the idea of justice is not about technicalities. It's about the substance, substantial justice. And that raises a very fundamental question. What is the province? What is the overriding goal? What is the objective of electoral dispute adjudication? If I may provide an answer, in consideration of the democratic principle of one man, one vote, one woman, one vote, it is an exercise or an inquiry by the courts to determine who got the mandate of the electorate. If it's a general election, like the presidency, all those who are entitled to vote. If it's a senatorial election, those who are entitled to vote. If it's a primary, it's about all those who are entitled to vote, whether it's a delegate system or where all registered members of that party are entitled to vote. Who got the majority of lawful votes and made the legal or constitutional provision in respect of that particular election. So that is what the inquiry by the court should be about. It is not academic or intellectual gymnastics about a judge or judges being able to show how much of legal technicalities they know, because that will mean supplanting the question that they will have answered, the main question for determination, with another which has no relevance to the overriding goal and objectives. So if the question was who actually won a primary in a particular senatorial seat, you must come to that determination if a primary was held. Who got the majority of lawful votes and made the legal requirement? It is not about now employing technicalities. A council started a process, okay, with an originating process that was not the right one. He should have come by way of writ of summons instead of originating summons he used. In a sense, we are punishing the litigant for the sins of counsel, or indirectly put, not even the litigant alone, because we are discussing representation of a particular senatorial district. You are punishing the voters, the eligible voters who were at that primary, who made a decision, whose decision you should have respected as the court. That is the decision you should respect. You should find out what happened and respect that decision. And then the court somehow decides to give itself another direction. Because at the end of the day, you have not, that question about who actually got the majority of lawful and legal votes have not been resolved. And I think that is what is hanging. That is the crux of the matter in most of these cases, not just this one alone, where technicalities have supplanted substantial justice. Now, if you look at the Electoral Act, it talked about the methods of nominating candidates, whether you are doing direct primaries or whether you are doing the delegate system or whether you are doing consensus. And it also talks about the fact that you have to notify INEC. And they have to come there. It's mandatory to see what happened. You did a primary, you did not cancel it, you did not give any reason for attempting to cancel it, and the person now you're even saying had won did not participate. In fact, at some point it's understood he withdrew because he was looking out for something else. He wanted to be a presidential candidate. And when he fell, he now ran back. You did not cancel the first primary. And of course, the second you purportedly held was not observed by INEC. So where exactly is the foundation for declaring such a person? Are you supposed to be running for the presidency and Senate seat at the same time? I mean, this is ridiculous. Can't somebody make up his mind where he wants to be? And for him, talking about victory for democracy. So let us allow him. He could have been the presidential candidate and the senatorial candidate. This is the height of greed on his part. Because we even understood he didn't even proceed further. And he's now talking about a victory for democracy. So I think it should be clear to anybody that the courts should properly direct themselves on the question, on the issues in dispute. What has happened is like a student who the teacher and the examiner set an examination for. And he went into the classroom on the examination day and decided to set an examination for himself and answered the question and now starts rejoicing that he has passed the examination. Who set the examination for you? Nigerians, just like we are the masters, we are the employers of the president, we are the employers of the legislator, we are also the employers of those who serve in the judiciary from the Supreme Court down. And the mandate we gave them is clear. This is jurisprudential. It is beyond anybody thinking he has ultimate powers. We are saying, what mandate did we ask you to do? What did we ask you to do? To delve into technicalities or to determine who actually had the lawful and legitimate votes? And that's the question. If you have allegations of a crime or fraud, issues that are in dispute, you should come by way of writ of summons. I mean, since you need to take evidence, because originating summons is like we all agreed on the facts. We simply want the court to pronounce on the legal issues. But should that overtake the substantive question? Should the procedural question come first before the substance? What was at stake? Was it the form of the originating process? Or was it, I won the primary, so I'm the candidate? You affirm that you won the primary, you are the candidate. That is the question before the court. Any other one is like leaving the question, like I did say, simply walking into an examination hall, somehow ignoring the questions that were set by the examiner, proposing a question for yourself, answering it, and affirming, which has nothing to do with the original question set by the lawful authority, which is the examiner, and then simply shouting Eureka. The law is what the judges declare to be law and nothing more pretentious. But of course, law is written in English language, and all of us went to school. And beyond those sitting in the bench, other lawyers are just at the bar. And other Nigerians can understand what is going on. I don't think when professionals begin to mystify and technicalize otherwise very simple things, that's what leads to problem. There is nothing in the world that is so technical that an ordinary literate fellow cannot look through it and, try to understand what is happening. The sense of justice is a natural sense God implanted in all of us.